Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
Liberty Counsel will appeal recent Ten Commandments ruling. I'm Matt Barber, Director of Cultural Affairs with Liberty Counsel and Associate Dean with Liberty University School of Law, in for Matt Staver today. And joining me in studio is Sean Akers, Dean of Liberty University's Helms School of Government and Policy Analyst with Liberty Counsel. Well, Sean, Liberty Counsel has been really caught off guard here, and I think many people across the country have been surprised by a 2-1 panel decision that came down out of Kentucky federal court, where the panel, on a 2-1 split decision, ruled that a Ten Commandment display was unconstitutional. Now, Liberty Counsel intends to appeal this ruling from the Sixth Circuit Court of Appeals, which allows a permanent injunction against 3 displays of the Ten Commandments at the local courthouses in both McCreary and Pulaski County, Kentucky. And the decision, in the 2-1 decision, 2 of the judges on the panel found that the purpose of the displays was a religious purpose rather than an educational purpose, and therefore it violated the Establishment Clause of the First Amendment of the United States Constitution. Now, the dissenting opinion, I think, says quite a bit. It was written by Judge James L. Ryan. It recommends a rehearing in front of the full Sixth Circuit panel of judges based on the multiple rulings under very similar circumstances that had exact opposite outcomes. He wrote, quote, and this is Judge Ryan, wrote, quote, "Perhaps the panel's decision in this case, taken together with this court's decisions in ACLU versus Mercer County and ACLU versus Grayson County," again, Sean, cases where under very similar, almost identical circumstances, the court upheld the constitutionality of Ten Commandment displays. He said, continuing, he says, "Hopefully, these cases will move our court to reconsider en banc what my colleagues have held today, from which I strongly dissent." Sean, and now, for the purposes of those listening, explain what en banc means here, but ultimately what Judge Ryan is recommending.
Well, Matt, there's a process that is meant to stand as a safeguard for poor decisions at the circuit court level, and what it does is create another option to filing with the Supreme Court. Instead of filing directly with the Supreme Court, what you may want to do is have the entire circuit court take a look at the same opinion and see if they want to change their minds about it. Now, what they mean by en banc is where when you appeal a case, you typically go before a 3-judge panel. There are many more than 3 judges that make up the entire circuit, though. En banc means that they're going to pull all of those judges together and have all of the judges weigh in, not just the 3 that filed the original decision, and then make a determination of whether that decision shouldn't be reversed by the circuit court itself, so there's no need then for us to have to appeal it to the Supreme Court. It's a great place to start, and to have such a strong dissenting opinion by one of the judges of the 3-judge panel is an excellent position for us to be in under the circumstances.
Absolutely. Well, Judge Ryan continues, quote, "I cannot be too critical of my panel colleagues who feel stare decisis, bound by the Supreme Court's majority persistent hostility to religion and its refusal to acknowledge the historical evidence that religious symbols, and the support of religious devotion were the very essence of the values of the Constitution's authors, and the ratifying legislators thought they were preserving in the language of the First Amendment." Boy, what a powerful statement there, and I will try to paraphrase what he's saying here. I think he is saying that these 2 judges got it completely wrong. They're ignoring what was in the minds and the clear writings of the Founding Fathers. And they're even ignoring stare decisis, that the United States Supreme Court has found over and again the importance of our religious history in terms of our foundations of law and so forth. And of course, stare decisis is the respect or the recognition that a court gives to precedent, to cases that have already been ruled upon at the highest level by the United States Supreme Court. So he's really chastising his colleagues here, the two that on this panel that ruled really inexplicably that because, in their opinion, what was in the mind of those who developed these Ten Commandment displays, that somehow they had a religious motive for doing so, this display is unconstitutional, whereas a display identical to that would be constitutional if the motive of those putting up the display was educational in nature. And boy, talk about splitting hairs, and talk about demonstrable hostility toward religion. Boy, I thought the Constitution said a little something about not recognizing an establishment of religion or prohibiting the free exercise thereof. Boy, as so many on the left seem to do, and I don't know that these judges are leftists, but they certainly appear to have bought into this notion that this of separation of church and state, that there can be no reference to religion anywhere in any public forum.